Let me be very clear about what we are talking about here. We are not talking about a clerical error. We are not talking about a filing mix-up or an administrative slip between overworked paralegals. We are talking about two medical documents, both submitted in the same federal court proceeding, both purportedly drawn from the same examination window, that say the exact opposite thing about the health of the most powerful man in the country. And a federal judge, 22 years on the bench, former federal prosecutor, not some activist appointee, held them up simultaneously in open court on Tuesday morning and said, and I'm quoting directly from the official transcript, "Counsel, I'm looking at two documents that cannot both be accurate." Explain that to me. Trump's lead attorney asked for a recess. He got 7 minutes. He came back with nothing. Nothing. That is where we are. Let me take you through this properly, because the coverage of this story has been frankly embarrassing. Everyone is chasing the visual, the judge, the documents, the dramatic pause, and almost nobody is actually reading the 47 pages. I have, twice. So let's do this right. Trump, the 47th President of the United States, is currently facing a civil contempt proceeding in a federal courtroom in Washington. The underlying dispute began about 8 months ago when the Federal Oversight Panel, formerly known as the Executive Conduct Review Board, requested voluntary testimony from Trump related to financial disclosures. Routine, on paper. But Trump's legal team did what Trump's legal team always does. They delayed. And the justification they chose? His health. About 5 months ago, they filed the first postponement request, citing medical grounds. Granted, no controversy. About 3 months ago, they filed again. Same justification. The panel's internal minutes from that period, released later through a Freedom of Information request, buried in the news cycle, barely noticed, show that even then, panel members were skeptical. One member wrote on the record, "We are no longer satisfied that the stated medical grounds reflect the actual situation." 3 months ago, nobody picked it up. The story was already there, and nobody was reading. Then came last week. The oversight panel formally demanded the underlying medical records. And here is where it gets genuinely remarkable, because Attorney General Pam Bondi's office complied. They produced the records. Whether that was deliberate or an error, whether someone inside the Justice Department made a conscious decision to let the truth land in that courtroom, is a question that has not been answered and may not be answered easily. But the records went in, and the records were devastating. Here is what Trump's health declaration actually says. I am going to read this to you from page 9 of the filing, because I want you to hear the clinical precision of this language. Language that was crafted to carry legal weight. Language designed specifically to tell a federal court that Donald Trump could not sit for extended testimony. Quote, "The patient exhibits significant cardiovascular limitation, precluding extended periods of physical or cognitive exertion without medical risk." Significant cardiovascular limitation, precluding medical risk. That is not casual. That is a legal instrument dressed in medical clothing. Now let me read you what the DOJ produced. Page 31. Different document, same examination window, same court record. The physician's own internal progress notes. Quote, "The patient demonstrates age-appropriate cardiovascular function. No acute limitations identified. Activity restrictions are not recommended at this time." Read those two things back to back. Significant cardiovascular limitation. No limitations identified. Activity restrictions precluding testimony. Activity restrictions not recommended. These are not different interpretations of the same data. These are opposite clinical conclusions, and they both sit inside the same court filing. But wait, because this is actually not even the most alarming part, and that is saying something. Buried in the filing, page 44, footnote 7, there is a cross-reference. The physician who signed the limitation declaration, the document that told a federal court Trump was too unwell to testify, that physician's name does not appear in the White House Medical Unit's official personnel roster for the relevant period. 19 months of records. The name is not there. The doctor who provided the medical justification for missing federal testimony may not have been the treating physician on record, at all. Judge Patricia Hensley noticed all of this. At 11:14 in the morning on Tuesday, in open session, she raised it herself. She did not wait for a motion. She did not schedule a hearing. She held up both documents, named the contradiction out loud, and demanded an explanation in real time. Callaway, Trump's lead attorney, asked for a recess, 7 minutes, came back and said his team needed time to investigate. He asked for a 48-hour continuance. Hensley denied it. She gave him until Friday. And then, and this is the part everyone missed, because they were all writing about the visual of the judge holding up 2 pieces of paper. While the courtroom was still processing what had just happened, Bondi's office quietly filed a 2-page supplemental notice at the bottom of the docket. It stated that the DOJ has additional medical records beyond what was produced Tuesday, and that those records are, quote, currently under privilege review. Hensley saw it. She asked DOJ counsel directly. They said they couldn't characterize the records. Hensley's response? She set a deadline, July 3rd. All records, privileged or not, submitted for in-camera review. She will examine them privately and decide what stays and what comes in. In-camera review. Let me be specific about why that matters, because this is where the legal professionals land who have actually prosecuted contempt cases. A former federal prosecutor with 11 years in the Justice Department Public Corruption Unit put it plainly this week. When a judge orders in-camera review, rather than waiting for the parties to resolve privilege disputes themselves, she is signaling she does not believe the privilege claims are being made in good faith. That is not me editorializing. That is someone who has stood in those courtrooms and tried those cases, telling you what that order means. Hensley thinks someone is using privilege as a stall tactic, so she cut around it. She is going to look herself. A former assistant United States attorney from the Southern District of New York, now 2 decades in criminal defense, made the point that I think is actually the central one in this entire story. Medical declarations submitted to federal courts require a verifiable signatory. If the physician's credentials do not hold up, the declaration itself can be struck. And if the declaration gets struck, every postponement granted on the basis of that declaration gets reviewed retroactively, which means everything Trump's legal team bought themselves with those delays, the time, the avoided testimony, the months of procedural cover, it all becomes the foundation of the contempt argument against them. Now, I want to be fair here, because there are serious legal voices making arguments on the other side, and some of those arguments have genuine weight. Trump's defenders point first to executive medical privacy. There is real legal debate about the extent to which a sitting or former president must disclose health information to an oversight body, particularly one whose jurisdictional authority has itself been challenged in prior filings. That is not a frivolous argument. The oversight panel's standing has been contested twice, neither fully resolved. Courts have not uniformly addressed the privacy framework around executive medical records. Second, Trump's legal team is now arguing that Bondi's office released these documents without completing proper privilege review, and that the records causing this firestorm should not be in the court record at all. Former White House counsel Bradford Simmons, who has represented clients across both parties and who is no ideological ally of this prosecution, said explicitly this week, procedural production errors do not become substantive admissions. The manner in which documents enter a record matters legally. And the American Bar Association's formal ethics commentary, cited in a Trump legal brief filed Monday, does acknowledge that medical documentation in executive proceedings carries distinct confidentiality considerations not present in standard civil litigation. These are real arguments. I am not dismissing them. When both sides can cite legitimate legal authority, you are in genuinely complicated terrain. But, and this is a very significant but, even a constitutional law professor at Georgetown, someone who has written publicly skeptical of this oversight panel's authority, someone whose op-eds have supported Trump's legal position, said this week, whatever one thinks of the panel's standing, 2 irreconcilable medical documents in the same proceeding is an evidentiary problem that cannot be explained away procedurally. When someone on the other side of the argument says that, you should listen carefully, then Trump himself weighed in, because of course he did. Within 3 hours of Tuesday's session ending, he was on Truth Social, calling the proceeding a, quote, weaponized medical inquisition run by Bondi's rogue office. He said the documents were stolen and misrepresented by judicial activists. His own office walked it back slightly within an hour. Understandable frustration, not a formal legal position, the usual cleanup operation. But the oversight panel's attorneys had already screenshotted the post and submitted it to the court record by Wednesday morning. Public statements attacking the proceedings while contempt is being actively weighed. The legal commentators across the ideological spectrum flagged it immediately. Then Callaway filed a recusal motion against Hensley herself, citing a speech she gave in 2021 about executive accountability as evidence of bias. Hensley denied it Wednesday morning. 2 paragraphs. No elaboration. Just denied. Filing a recusal motion during active contempt consideration is not a sign that you have a clean answer to the physician credential question. It is a sign that you are building an appellate strategy because you don't have one. Here is what is still unknown, and this matters because the story is not finished. The identity and credentials of the physician who signed the health declaration have not been confirmed by Trump's team. The court has not forced disclosure yet, but Friday's joint evidentiary timeline will almost certainly require it. The additional records the DOJ flagged in the supplemental notice, nobody outside that privilege review process knows what is in them. If they support the limitation declaration, this case looks very different. If they support the progress notes, the situation accelerates dramatically and quickly. And then there is the question I have not stopped thinking about since I went through these filings. Bondi's office produced these records. They knew what was in them. Somebody in the Justice Department made the call to hand them over. I am not telling you that Pam Bondi moved against Donald Trump intentionally. What I am telling you is that someone in that building made a decision, and that decision put two irreconcilable documents in front of a federal judge with 22 years on the bench. That is not nothing. That is possibly everything. The deadlines now are specific. Friday, June 27th, noon Eastern. The joint evidentiary timeline is due. Both parties, every document, every signature, every date. That is not standard practice. That is a judge building a record. Tuesday, July 1st. The White House Medical Unit must have a sworn representative available for questioning. July 3rd. All additional medical records due for Hensley's in-camera review. The week of July 7th. A contempt ruling is expected, pending what Friday's submission contains. The question everyone informed is watching Friday is not whether Callaway files. He will file. The question is whether he names the physician. That answer tells you everything about whether Trump's legal team has a legitimate explanation or whether they are simply running out the clock and hoping for appellate intervention before July 3rd. What this case is actually establishing, beyond Trump, beyond this specific proceeding, is something that will matter for years inside federal courtrooms across this country. The legal question being decided right now is whether medical documentation can be used to indefinitely delay compelled federal testimony. If Hensley finds contempt and the Friday submission is inadequate, the formal answer becomes no, not without rigorous, independently verifiable medical evidence. Courts cite each other. Standards written in high-profile cases become the floor for the cases that follow. There are roughly 340,000 active civil cases in federal district courts right now. Medical documentation is submitted in a significant portion of them. If this case tightens the verification requirements for medical declarations, the ripple is real and it extends far beyond anything involving this defendant specifically. But let's be honest about where we are today. Sworn medical evidence was submitted to a federal court to justify the postponement of compelled testimony. The Justice Department produced records from the same examination period that contradict that evidence directly. The physician who signed the declaration may not have been the patient's physician of record. A federal judge has ordered in-camera review of all outstanding records because she does not trust the filtering process. And the President of the United States responded by calling it a weaponized inquisition on a social media platform that his own legal team then had to publicly distance itself from within the hour. That is not a procedural dispute. That is not a scheduling disagreement that got out of hand. That is the legal architecture of obstruction being examined in open court by a judge who has decided she has seen enough. The documents are in the record. The contradictions are on the record. The clock is running. And Friday at noon is where we find out whether Donald Trump's legal team has any answer at all, or whether they are simply hoping the appellate system moves slower than the truth.